I'm Brittany Lewis with Forbes Breaking News. On Thursday, a House Judiciary subcommittee held a hearing on clemency and the Office of the Pardon Attorney. Congressman Jerry Nadler asked witnesses about how a lack of access to clemency, along with the burden of criminal conviction, may prevent successful reentry and reintegration for the formerly incarcerated. Listen in for the witnesses' response.
And thanks.
Thank you. Thank you very much. And I now recognize the chairman of the full committee, Mr. Nadler, for 5 minutes.
Thank you, Madam Chair. Professor Osler, because the federal system lacks expungement opportunities for individuals, the only relief they can get from the collateral consequences of conviction is through the clemency process. Can you explain how the lack of access to clemency, along with the burden of a criminal conviction, prevents successful reentry and reintegration?
Yes, I can. And part of the reason I can is because I run a clinic at my school where we represent people for pardons. We know what it means to them. And every case is going to be different, of course. But for example, it may seem mundane, but there are pardon petitions from people where what they want to do is go hunting with their grandchild. But they can't, because they can't possess a gun. And that may be a little thing to some people, but it's a big thing to that grandfather. There's people who can't get a license to do the job that they want to do. And perhaps most importantly, many people just want to feel whole again. They want to feel that they have moved past, that it's recognized that they are no longer the person that committed that crime. And that's what pardons can do. And unfortunately, this system serves commutations poorly. It serves pardons even worse. Thank you.
Why do you say that it serves pardons even worse?
Well, for the last, during the Obama presidency, during the Biden presidency, there's been an emphasis on commutations. And because the bandwidth is so thin from the pardon attorney on up, when they're focusing on commutations, pardons get shunted aside.
Thank you. Professor Barco, in your testimony, you discussed the possibility of removing the clemency process entirely from the Department of Justice. Can you explain how that would help address the bureaucratic barriers and increase relief for individuals seeking clemency?
Sure. It would effectively get rid of that chart. And so you would have a body that replaces it, provides all the information to the president, and then the president still makes the ultimate decision. And the president could tell that advisory body how it wants to run. It could say, look, these are the cases I want to prioritize. This is the way I want you to look at petitions. I want you to favor this category or this kind of person. But what you would effectively have is a dedicated board that is supposed to just do clemency. What you have in that chart is you have one office that does that, which is the Office of the Pardon Attorney, which is woefully understaffed. And then it has to go through these other two places in the chart where the White House counsel and the Deputy Attorney General, they just are prioritizing other things, and not unreasonably so. And so placing an advisory board that is just designed for clemency gives you the benefit of specialization and efficiency. It takes away any kind of bias that exists from having the same agency that brought the case make the final decision. You still get input from the Department of Justice. You still ask about facts of the case from prosecutors, but you have it be evaluated by an objective party that doesn't tilt on one side or the other, is just trying to think what is the best outcome and advice to give the president.
Thank you. Ms. Taifa, in your testimony, you discussed the need for clemency to fix past wrongs that led to mass incarceration, such as mandatory minimums and other harsh sentencing. How can improving the clemency process address the ongoing racial disparities in the criminal justice system and make the system more equitable and fair?
In my testimony is through categorical clemencies, looking at groups of people. Because mass incarceration has been so massive, the solution to it needs to be massive as well. There is precedent for it. We have talked about the Ford clemencies for Vietnam-era draft resistors that happened also with respect to Carter, and it was very effectual, and there was no danger to public safety or anything along those lines, but it sought to correct issues and help to heal the nation, because that was a very controversial time. Mass incarceration is controversial.
But excuse me, but that was a categorical clemency to an entire class of people. You're not talking about that.
Well, actually, I am. I'm talking about various classes of people, one of which I spoke of was the class of old law prisoners who were sentenced before 1987, before the sentencing guidelines went into effect. They don't have any recourse, and clemency is basically their only avenue that they have for release. They have no benefit from the First Step Act compassionate release processes, and the parole board has been basically ineffectual.
Thank you very much. My time has expired. I yield back.
I thank